Good afternoon, everyone. I apologize for the delay, but we can get started now. And we have Courtroom 2. Ms. Armstrong, Ms. Gant. Are you both got multiple cases or just a particular case, Ms. Armstrong?
I think we both have multiple cases.
Okay, good. Sometimes you chime in with just one case, so I want you to be sure.
We're both in it today. Thank you.
All right. Okay, Ms. Arnold's here. Ms. Arnold, you on your own or someone else?
Good afternoon, Your Honor. Yes, Ms. Webb is here, or she should be here to help me.
Okay, good. All right.
Yes, I'm here.
All right. Good afternoon. Good
Good
afternoon.
afternoon, Judge. How are you?
All our usual suspects are out there, and we're going to begin with Courtroom 2. Good afternoon, ladies and gentlemen. My name is Judge Lal. This is going to be the Fulton State Expedited Accusation Calendar. This is a list of cases in which individuals have been recently arrested and booked at the Fulton County Jail. Upon being booked, the Solicitor General's office, which is the prosecutor, has already accused the defendant of one or more misdemeanor offenses. Therefore, you have a formally accused case that's now bound over to the State Court of Fulton County, and this would be the defendant's initial appearance before a judicial officer. If you are a defendant accused of one or more misdemeanor charges, please remember that you have a right to remain silent. Anything you say during the course of this virtual court proceeding, your statements will be recorded and used against you in the treatment of your case. So please remember to remain silent about the facts of your case and let your appointed counsel speak on your behalf. You have a right to an attorney. If you cannot afford one, one of our attorneys from the Public Defender's Office will be representing you. If you have a private attorney, please let us know when I call your case. Courtroom 2, who do we have in the seat, please?
This is number 4, Ms. DeBose.
Thank you, sir. Beverly DeBose is accused of battery, domestic violence from March 2nd, 2022 in case 22 CR 001168F. Ms. DeBose, your attorney is going to be Ms. Wanda Gant. And Mr. Tucson, any priors?
A third arrest, 2009 criminal trespass, and another 2009 criminal trespass.
Thank you. Ms. Arnold?
Yes, Your Honor, and I put it in the chat. This one will need to be a breakout.
All right. Ms. Officer, can we place Ms. DeBose on hold right now? I'll take up the other cases.
Sure.
Thank you.
Your Honor, the defendant's daughter, also the victim in this case, I'm not sure if she's here yet, but she did ask if she could be a part of the breakout, if Your Honor would allow.
Sure. I'll take that up shortly. Let me take my other cases up first.
Okay.
We go to number 2, Mr. Clay.
Thank you. Mr. Ryan Clay is accused of criminal trespass from March 1st, 2022 in case 22 CR 001166E. Mr. Clay, you've been advised of your right to remain silent, and your attorney is going to be Tom Ford.
Hi, good morning, Your Honor. How are you?
Okay, it was not a spontaneous outcry. It was just, are you representing Mr. Clay?
Yes.
Oh, okay, good.
Yeah. I was been trying to hear you talk to you, and you just called my name, and here I am. So good to see you.
All right. So Mr. Clay is going to be represented by Mr. Tom Ford. Mr. Tucson, any priors on Mr. Clay?
First, he's 17 years old.
All right. And Ms. Arnold, any objection to a signature bond or a, are you all looking for a cash bond for the 17-year-old?
No, Your Honor, we were requesting a $2,500.
You JR, come on. Guys, use JR, come on. Come on. No money, no money. We spent 3 days in the jail that you never been arrested for. Come on.
I'd really appreciate it if the defense wouldn't interrupt the prosecuting attorney while she's giving her presentation of the facts.
Understood,
Didn't
Ms.
realize I was. I beg your pardon.
Mr. Ford, I'll give you an opportunity. I understand. Thank you. Ms. Arnold, excuse us for Mr. Ford, and he means it in good spirit. So
He does.
All right, Ms. Arnold, again, what was the claim now for, you wanted a signature bond or a surety bond?
Yes, Your Honor. The state is requesting a $2,500 signature bond with well, I don't know if defense will have better knowledge about whether this, since it is a 17-year-old, we do have it in here with the stay away from the 590 Oakstone Glen in Milton, and no further contact with Reginald Clay, and no drugs, alcohol, or weapons. Your Honor, this is just based on the facts of this case where the defendant dumped water on Mr. Clay's papers and drew on his office walls with a pencil and removed a cork board from the wall. So we are recommending that $2,500 signature bond.
And no contact and stay away?
Well, again, we're not sure if there's some light shed on whether he has somewhere to go or not since he is 17.
All
So
right.
we'll refer to the court on that.
Mr. Ford, what does your client's family want to do?
Sure, happy to shed some light, Your Honor. We've got, this young man has a condition that years ago was overdiagnosed as bipolar. It is now something quite less than that. His father can provide insight on that to your pleasure. He is on the call as well, Mr. Reginald Clay. In the 2 or 3 instances that have existed with this young man who I met yesterday, the father has made the phone call to Milton Police for the simple purpose of having a show of authority, modulate, modify his young man's response, and there's been no issue therefrom. He is going to the University of Cincinnati next fall. He lives with his father, mother, and sister. He has to return to the home. He has to have no violent contact, of course, but he has nowhere else to go. The father and the mother are greatly disturbed that the sergeant at Milton Police Department made the decision this time to choose to arrest. At the end of the day, the only reason it was charged family violence is because he lives in the home. There's nothing destroyed of any consequence. This is an absolute big to do about nothing. He should have been on the first appearance calendar yesterday, but they didn't book him in until 5 a.m. So we've now got 36 hours at Rice Street to think about appropriate conduct, which is 34 hours more than he's needed. He is polite. He's an AB student. It should be a signature UJR bond. And when the solicitor's office ever gets around to prosecuting cases again, they'll recognize this should be dismissed post haste respectfully. Mr. Clay is on the phone for you to inquire.
All right. The bond's going to be set at $2,500. It's going to be a signature bond through pretrial services. I'm going to allow Mr. Reginald Clay to co-sign the bond. Junior Ryan Clay only need to report to pretrial services once a month, and I'm going to allow him to do telephonic reporting, and he needs to be medically compliant as well. If he's got any treatment or medication for his particular condition, he needs to be medically compliant.
Yeah, he's doing the same, Your Honor.
All right. No further violent contact with Reginald Clay. And it'll be further notice to a plea and arraignment calendar to be sent to his mailing address. All right.
Thank you again for another solemn-esque decision, respectfully.
Appreciate it. Thank you, Mr. Ford. You have a good one. Thank you.
Likewise, Your Honor. Thank you. Mr. Clay, yes, go ahead.
You waiving the utility bill?
Yes, I will waive the utility bill.
All right, so tell the daddy he needs to bring a valid license.
Yes, I think
1101
Mr. Clay, Mr. Clay, are you on the Zoom? All right, sir.
I am.
All right.
I am.
All right, Mr. Clay, all you have to do is come down to the pretrial office on Wright Street. You would need to co-sign the bond. It takes about 24 hours to process your son out of the jail facility. And make sure you have a current valid driver's license. And your son will need to, I'll allow for telephonic reporting through pretrial services. And he's to have no further violent contact with you. In other words, no physical or verbal altercation with you. And he needs to be medically compliant with regards to any condition he may have. All right. If he gets arrested again for anything else, or if he fails to report, as your attorney will advise the family, unfortunately, the signature bond will be surrendered and he'll be back in jail, which, as we all know, could jeopardize university opportunities.
Yes.
All right.
Yes, Your
Okay.
Honor.
Thank you, Mr. Clay. Mr. Ford, you have a good one. Take care.
So Judge, I put in
Pleasure.
the
Thank you.
chat.
Likewise. Thank you.
Thank you, Mr. Tucson.
I put in the chat for the dads to the directions on where he needs to go.
Okay. All right, Mr. Clay, I think you'll see the directions to the facility in the chat feature. All right,
I'm sorry,
it?
the directions?
If you look
Sir,
at
it's in the,
chat.
yeah.
I see, I got you.
Okay, thank you. Oh,
Thanks.
sorry, April, Holly, sorry. Next case,
Number 14, Mr. Rozier.
all right, that's going to be a hold also. We need a breakout on that matter, so that's going to be on hold. Next one, please.
Number 12, Mr. Kimbrough.
Kimbrough. We have Donovan Kimbrough, case number 22 CR 001176J, accused of DUI under the influence of alcohol, less safe, and improper or erratic lane change. Mr. Kimbrough, you've been advised of your right to remain silent, and your attorney is going to be Sarah Armstrong. Mr. Toussaint, any priors?
No.
Ms. Webb, what are y'all seeking?
Yes, Your Honor, the state is seeking a $5,500 surety bond, $5,000 for the DUI and $500 for the lane change, Your Honor. This incident, as Your Honor knows, occurred yesterday around 2 a.m. at 101 Grove Way, Roswell, Georgia, where the Roswell Police Department responded to an accident call. And upon their arrival, they were met with a resident of the community who informed the officer that upon her return home from picking up her husband, she realized that her neighbor's Nissan Sentra was hit and impacted on the side, and she did not notice that before. She also informed the officers that while she was coming into her home, she realized a Honda Accord had impact as well that did not have impact before, and she noticed a damaged Toyota RAV4. The officers went to investigate and made contact with the defendant who was sitting in that RAV4, Your Honor, and the defendant informed the officers that he was on his way home from work when he felt his car hit something, but he wasn't sure what he hit. He told the officers that he was returning from working a 13 to 14 hour long shift at a tavern located in Alpharetta. The officer did suspect that the defendant was under some type of influence, but he did not see any physical cues in the defendant's eyes or smell any alcohol coming from his person. However, as the conversation with the defendant proceeded, the officers realized that he was indeed intoxicated. The defendant began shouting randomly, swaying around, and almost stumbling completely over, and told each officer on the scene a different story as to how those collisions occurred on that property. The officers proceeded with a field test where some, but not all, cues of intoxication were present, and the defendant was then placed under arrest and transported to the hospital to be cleared for any injuries that he may have sustained. Your Honor, the state is making this recommendation because we do believe at any time that someone drives under influence of alcohol, in considering the distance between Alpharetta and Roswell, and he damaged other people's vehicles, Your Honor, that always poses a threat to the community, because now those residents, innocent residents, are having to deal with the battle of getting their cars fixed, Your Honor. Those are the basis for the state's recommendation. In addition to the surety bond, Your Honor, the state is also requesting no alcohol, drugs, or weapons while out on bond, and no driving.
All right, would it be fair to say that he didn't detect an odor of alcohol and there's been no admission of drinking according to the warrant, but it's just based on the mannerism and the alleged conduct? Is that?
Yes, Your Honor. It's actually based on, so the defendant, they did conduct a field test. So he did show some of the cues. I believe there's 6 factors in a field test. He may have showed 2 or 3 of those factors, including the walking and not being able to stand and walk a straight line,
So
and telling the officers 3 different stories to each officer who was on the scene.
So it could be DUI, alcohol, or drugs, or both.
Right,
now,
yes,
we
Your
don't
Honor,
have
which
enough
we're still-
evidence of alcohol. Okay,
Yes, Your Honor.
all right. Ms. Armstrong?
Thank you, Judge. My client worked an 11-hour shift, actually 13-hour shift that day. He woke up around 9 a.m., went to work at 10 a.m., worked until 11:30 p.m. At some point during that shift, he's serving alcoholic beverages, and my client reports that sometimes, and actually often, because this is a tavern, he will have alcohol spilled on him. After he finished his 11:30 shift, there were some kitchen duties to attend to. That's why he's out at 2 a.m. going home. There was a pothole in the road that my client encountered, and unfortunately that, perhaps combined with the fatigue of being awake for so long that day, There was an alleged vehicle collision. My client stopped. He was compliant with the officers who approached him regarding the alleged incident. This actually happened down the street from his apartment. He was right outside of his apartment when this happened, almost home. It would be the defense's argument. I understand this is bond, but it's the defense's argument at trial that the law enforcement officers unlawfully extended his detention because, quite frankly, they did not have reasonable suspicion of a DUI to turn this accident investigation into a DUI investigation. Then all of a sudden they smell alcohol. All of a sudden there's a DUI investigation. It's alleged that he had 6 out of 6 clues on the horizontal gaze nystagmus, but defense counsel argues that that is because he was really tired. He'd been awake a long time that day. And as your honor knows, sometimes fatigue looks like an alcohol positive HGN analysis. And then he didn't even have all the indicators for the one leg stand, nor did he have all the indicators for the walk and turn. He did agree and consent to a blood draw. We don't have the benefit of the blood draw test right now, what those results were. He was arrested for DUI less safe. He was also complicit or allegedly agreed to the fields test, but right now it's the defense's argument that he did not knowingly voluntarily agree to those tests. This is my client's first arrest, I believe, as I think I heard it. So we would actually be asking your honor for his signature bond so my client can get out and keep working. He does live alone, he supports himself, so it's really important that he be able to return to his job. And with respect to any conditions on his driving, I do ask your honor to just follow the recommendation for the administrative body that deals with DDS and in terms of any limitations to any possible limitations to his driving.
Your Honor, and if I may respond, the defendant did show, as you heard from defense counsel, all 6 clues of HDN, which is a mistakable indication of DUI, Your Honor. And defense counsel also stated that fatigue often shows up in those tests as DUI, but according to NHTSA, Your Honor, fatigue does not affect the HDN according to NHTSA, Your Honor. Nothing further.
All right, I think this whole case is going to be pending on the blood draw and depending on the information you get, Ms. Webb, your office gets, you all may have to amend the charge or
yes, Your Honor, absolutely. If of course, if the defendant is if we do not have the evidence to support the conviction, then we will not pursue charges, Your Honor, frivolously. We definitely want to conduct a full investigation, which is still undergoing. But again, those officers on the scene did have probable cause to begin a DUI inspection on the defendant, Your Honor, because of the fact that he did tell the officers 3 different stories. In addition to the stories that you told, you heard from the defense, he also told one officer that he stopped by his girlfriend's house for a few hours after leaving work and did not come straight home, Your Honor. So for those reasons, the state concedes. I
understand that, and
yes.
I don't know what to attribute that to, but otherwise, on the DUI is a $500 surety bond. On the erratic lane change is a $500 surety bond. It's a total of $1,000 surety. No driving unless he has driving privileges issued by DDS through the appropriate license suspension hearing. No illegal drugs, no alcohol, no weapons, and no firearms. Next court date, Holly, what's the next reset date?
SAP is March 17th.
Reset date is March 17th. If Mr. Kimbrough makes bond, then he will get another notice to appear at a different court date. But presently, if he doesn't make bond, his next court date is March 17th. Thank you.
Thank you, Judge.
Thank you.
Ms. Grant.
We have Samar Shakiria Grant. Ms. Grant is accused of battery causing substantial physical harm from October 12th, 2021. Ms. Grant, you've been advised of your right to remain silent, and your attorney is going to be Ms. Sarah Armstrong. Mr. Tucson, any priors?
First arrest.
Right. Ms. Webb?
Yes, Your Honor. In this case, we are recommending a $3,000 surety bond. No further contact with Ms. Latanya Barnett. That's Latanya, Latanya Barnett, BRNETT. A stay away from the incident location at 2348 Cascade Road, Atlanta. one-day anger awareness, and no alcohol, drugs, or weapons. As Your Honor knows, this incident took place on October 12th of 2021, where Atlanta PD officers responded to a dispute call, and they were met by Ms. LaTanya Barnett, who informed the officers that the defendant had struck her in the face with a closed fist, causing her to sustain a bloody lip. Additionally, Ms. Barnett told the officers that during that altercation, the defendant also pulled her hair, Your Honor. Albeit that this is the defendant's first offense, we are concerned with witness intimidation in this case, and a risk of reoffending, Your Honor, for if whatever happened that night is still ongoing. We are concerned that there is a possibility of reoffending. We did reach out to Ms. Barnett, Your Honor, but we were not able to make contact today.
All right, thank you. Ms. Armstrong?
Thank you, Judge. This did happen in October. This was at my client's previous place of employment. The complaining witness was, I believe, in a supervising role. My client did confront her about withholding her paycheck. And then there was an alleged altercation in which my client sustained injuries to her hands. Her fingernails were ripped off, but that was not investigated. This was mutual combat that was started by the complaining witness. My client's only 20 years old. She lives with her parents and she's attending college studying to be an RN. We are asking Your Honor to grant a signature bond in this case because not only is she eligible for one, but she really needs to go home and keep studying so she can advance her career and contribute to society, especially in a time where nurses are very, very needed. With respect to the state's claim of reoffending, there's absolutely no basis for any claim of that she could reoffend. This is her first arrest. Moreover, any risk of witness intimidation. There's no evidence that my client's attempted to make any contact with the complaining witness since October. My client no longer works at the location where this allegedly occurred. She has a new job and she's in school.
Bond is set at $2,500. This is a signature bond through pretrial services. No further contact with LaTanya Barnett to stay 200 yards away from that location, 2348 Cascade Road. No illegal drugs, no alcoholic beverages, no weapons, and no firearms. Ms. Grant, if you have aspirations to be a registered nurse, keep two things in mind. Number one, it is a professional license for which you have to apply. And number two, having issues like this on your record is going to create a huge hurdle to being a nurse. Do you understand? So work very well with your attorney to get this resolved. And I can pretty much guarantee that Ms. Barnett is not going to be writing you a letter of recommendation. So please be mindful of this in the future. Your next court date is going to be sent to your current mailing address that we have on file. And you need to show up in court. Make sure you do. Otherwise, you get a bench warrant for your arrest and you lose your signature bond. You must report to pretrial once a month. And if you get arrested again for anything, well, bring $2,500 with you to the jail. Understood? Thank you.
Next, we have number 10, Ms. Hoyt.
All right. Jenna Hoyt, case 22 CR 001164F, is accused of having a unlawful conduct during a 911 call by using obscene/vulgar language to intimidate/harass 911. Alleged incident date is February 7, 2022. Ms. Hoyt, you've been reminded of your right to remain silent, and your attorney is Ms. Armstrong. Mr. Tucson?
5 total. Last arrest was last month in Forsyth County for simple battery family violence. That's open. She had 2 arrests in 2014 in New York. Driving while impaired, those were convictions. And had a 2007 public place cause disturbance out of Florida. So she got the open case in Forsyth.
And I'm sorry, when did you say that was?
February 12th.
Of this year?
2022. Yes, yes.
All right. Ms. Webb? Was it Miss Arnold? Sorry, Miss
No,
Webb?
Your Honor, that is
Okay.
actually my case. Yes, Your
Oh.
Honor, as Your Honor, oh, excuse me. In this case, the state is recommending a $3,500 signature bond, no further contact with Miss Jessica Lusk. That's Jessica's common spelling, Lusk, SLUSK, no alcohol, drugs, or weapons, and 1-day anger awareness. Your Honor, this incident took place on actually between 2 days, February 7th and February 8th. On February 8th, a Roswell Police Department were dispatched to an intoxicated person complaint at 6092 Eagles Crest Village Lane. Ms. Hoyt had called 911 multiple times throughout that evening about stolen house keys. She wanted the officers to come out and sit outside of her house and wait for her girlfriend to return home. During the investigation, however, the domestic dispute, Hoyt advised that her girlfriend had stolen her keys and had fled to Cumming, Georgia. And she kept calling 911, asking them to do something about getting her keys back. Then she called 911 again, Your Honor, telling them that her girlfriend needed to be investigated for having drugs around children and wanted to report an incident of child abuse. The 911 operator told her that if she wanted to do so, that would be one, outside of Roswell PD's jurisdiction, and two, they would need to disconnect the call to connect her with the Cumming police. Your Honor, she responded by saying, okay, let those kids die, then it's on you, F you. Approximately 40 minutes later, she called back stating that her girlfriend was coming back to the house and stopping by and to send the police out. Your Honor, this case is interesting in the fact that she was attempting to use 911 services to harass Ms. Lusk. As you've heard from pretrial, she does have that simple battery case open out of Forsyth from that occurred on February the 12th of this year. Your Honor, we did reach out to Forsyth County to see if that involved Ms. Lusk. We were not able to make contact. However, considering that Cumming, Georgia is located in Forsyth County, there is reason to believe that perhaps that simple battery case, which occurred 4 days after this incident, does involve Ms. Lusk. The officer who responded to that scene did conduct an investigation, went to the office to get the security footage to see if Ms. Lusk was indeed on that property. He did not see her return back to the property on the day that Ms. Hoyt alleged, Your Honor. So for those reasons, we do believe that she has a risk of reoffending, considering that she did catch that charge after this one, Your Honor. And there was a previous incident from February 7th where she called the police to report an incident of assault between the parties, Your Honor. Nothing further from the state.
Ms. Armstrong, looks like there's a recommendation for a signature bond.
Yes,
Any
Your Honor.
objection? All
We
right.
welcome that. Thank you.
All right. The bond's going to be set at $3,500. It's going to be a signature bond through pretrial services. No contact with Jessica Lusk. To stay 200 yards away from Ms. Lusk. You cannot communicate with her in person. You cannot communicate with her through a phone or through a computer device. And you cannot discuss her on social media. And you cannot reach out to her through a third person, such as a police officer. You shall stay away from Ms. Lusk's residence, wherever she happens to be, employment, and so forth. No illegal drugs, no alcoholic beverages, no weapons, and no firearms. You'll be subject to random screens by pretrial office. If you fail a drug or alcohol screen, if you attempt to communicate with Ms. Lusk, or you use the police services to reach out to Ms. Lusk, that could be a violation of a signature bond. You are not to engage in any kind of violent communication with the law enforcement authorities. There shall be no use of vulgar language, harassing language, or continued harassment of the authorities unless there is a bona fide legal case. Your next court date will be sent to your mailing address. We have an address in Roswell. Is that a current mailing address?
Yes, it's 609-555. Eagle Ridge Crest Drive.
Is that your current address?
Yes,
Okay.
6092 apartment.
Your notice will be sent there. Make sure that you, if you change your address, you update us at the courthouse. Thank you.
That's per judge.
Yes. Holly, we need to write down for the open case. All right. Next case, please.
Number 11, Mr. Johnson.
Ira Earl Johnson Jr. is accused of battery domestic violence from March 2nd, 2022 in case 22 CR 001173B. Mr. Johnson, you've been advised of your right to remain silent. Your attorney is going to be Sarah Armstrong. And any priors, Mr. Tucson?
6 total. Resident of Minnesota. On probation in Minnesota for threats of violence. Last arrest was November 2020 for threats of violence. He had a robbery and burglary that was dismissed from 2020 with that arrest. Failure to change lane conviction as well out of Minnesota 2020. And a disorderly conduct, brawling or fighting conviction. It says 1 year probation. That's all.
What?
Well, yeah, 2017 domestic assault, but that was dismissed.
Okay, was that here or in?
Everything's out of Minnesota
Everything's out of Minnesota. All right.
on the looks of it.
Ms. Webb?
Yes, Your Honor, the state is recommending a $5,000 surety, no further contact with Ms. Kaylin Cameron. That's Kaylin, Kaylin, Cameron, Cameron, a stay away from the incident location at 1989 Treasure Bridge Road, Atlanta. No alcohol, drugs, or weapons, 1 day anger awareness, and third-party contact with the party's child. Your Honor, this incident, as Your Honor knows, occurred on yesterday, where the Atlanta Police Department responded to a domestic dispute call where that was actually reported by Ms. Cameron's neighbors who resided at that community at the incident location. A downstairs neighbor heard the sounds of a male and female fighting and went to the home to investigate and was pushed out of the doorway. It's unclear who pushed that neighbor, Your Honor, but he did return to his home and received a text message from another neighbor to call the police. When the officers arrived, they witnessed the victim with a busted lip and swollen lips and face. Ms. Cameron told the officer that argument started because the defendant did not like the person that she was having a conversation with on the phone at that time. Your Honor, you've heard from pretrial that the defendant is a resident of Minnesota, and all but this case of his history stems from Minnesota or in Minneapolis, Your Honor. For those reasons, the state does believe that he is a flight risk. Additionally, Your Honor, you've heard about those violent offenses and convictions and arrests in the defendant's history, and we're concerned that there is a risk of reoffending. And considering the facts of this case, that this level of violence was simply off of a phone call that she was having with someone, Your Honor, we are concerned with witness intimidation because those parties also have and do share a minor child together.
Okay, thank you. Ms. Armstrong?
Judge, this is my client's first time to Atlanta. We acknowledge that he lives in Minnesota, and I'm sure that's weighing on your mind when considering his bond. But he is in Atlanta because he and Miss Kaylin, that's the complaining witness in this case, they flew here together. They do have a child together. They are no longer in a romantic relationship. He is currently in a romantic relationship with a woman who just had a child. He has a newborn at home in Minnesota. Yet here they are in Atlanta celebrating the complaining witness's birthday. The Cheshire Bridge Road address is the friend or a friend of the complaining witness. That's where they were staying. They had gone out that night. The complaining witness was upset because my client was communicating with his current girlfriend, who's the mother of his newborn child. The police showed up. They actually took the complaining witness they were taking her to a different location. At some point during that ride, the complaining witness then makes up this story about my client beating her allegedly, but she left out the part that she was actually going at my client with a knife, and that my client reports having injury to his hand from attempting to grab the knife. So whatever injuries that were sustained by the complaining witness were a result of my client attempting to act in self-defense because he was in fear of his safety. Moreover, the complaining witness is also a resident of Minnesota. And my client reports that when this case is called for trial, he will fly back to Atlanta to be heard by the court to prove his innocence. So while we recognize that there is a concern of flight, he does say to the court he will show up when called, and we are asking for his signature bond in this case because there's so much outstanding evidence with respect to the allegations, and we haven't had the benefit of reviewing any body cam or 911. My client does hold down a full-time job. He's a truck driver with a major corporation. He needs to go back to work so he can continue supporting his family, especially his newborn, and his partner who is not working right now because she just had a child.
Bond is going to be set at 2,500. It is a surety bond. No contact with Kaylin Cameron, to stay away from wherever she happens to live or work or happens to be standing. You're not to communicate with her in person, nor through a third party, through social media, nor through any kind of electronic or computer device. You have to stay away from her place of residence, whether it's here or in Minnesota. You have to stay away from a person. And if you plan to have any kind of visitation or custody with the child you share, you would need to file the appropriate legitimation action. I don't know whether you do it up in Minnesota or whether you do it down here in Georgia, depending on where the child lives. And you would need a court order, legitimation court order to establish paternity, visitation, and custody. There cannot be any unilateral or a non-court ordered visitation unless there is a court order allowing it to be so. Your next court date will be March 17th. No illegal drugs, no weapons, and no alcoholic beverages. And that concludes this case. Thank you.
Number 13, Mr. McClennan.
Mr. McClennan, Daryl McClendon.
Hello.
Hello. Mr. McClendon's case is 22 CR, and that would be 001-165J, in which he's accused of simple assault and battery domestic violence from November 10th, 2021. I can't recall, Ms. Webb, is this an additional charge, or were there both two warrants in this one?
And second, this is it should just be for simple assault. I see the battery. Let me double check, Your Honor. We did have some issues with Odyssey this morning, so let me just double check there isn't an error.
Okay.
Oh, yes, Your Honor. This case does involve two separate victims, Your Honor.
Two victims. Okay. All right. Mr. McClendon, you've been advised of your right to remain silent, and your attorney is going to be Ms. Sarah Armstrong. Mr. Tucson, any priors, please?
11 total. Last arrest was 2018 DUI conviction. As far as violence, he has violence from the 1990s. Some were convictions, some were dismissed.
All right, that's good. Thank you. Ms. Webb?
Yes, Your Honor. In this case, the state is recommending a total $2,500 surety, $2,500 for the battery, and $1,500 for the simple assault, both surety bonds. No further contact with Ms. Destiny Huff. That's Destiny, DESTINY, Huff, HUFF, and Contressa Crowder. That's Contressa, CONTRESSA, Crowder, CROWDER. A stay away from the incident location at 2545 Old Hapeville Road. No alcohol, drugs, or weapons, and 1-day anger awareness. Your Honor, this incident took place on November 10th, 2021, where Atlanta Police Department responded to a dispute call and were met by Ms. Crowder, who was standing with her daughter, Ms. Huff. Ms. Crowder stated that her live-in boyfriend at the time, the defendant, struck her in the face twice with her own cell phone. She then said he proceeded to lock her out of that house and take her car keys inside of the residence to where she could not leave. The officer did observe that Ms. Crowder did sustain visible injuries with 2 hot knots on her left eye, and those injuries were captured by that officer's body camera, Your Honor. Her daughter, Ms. Huff, did inform the officers that while during this shuffle, that the defendant did strike her in the head, but the officer several times, Your Honor, but the officer did not see any visible injuries. Your Honor, we are concerned with witness intimidation. Our office did make contact with Ms. Crowder, and she informed us that the parties are no longer together and she does not reside at the incident location. However, she informed us that she did not wish to participate in these proceedings, but considering that this incident resulted in her sustaining those visible injuries and her daughter being struck in the head, the state is concerned that she is intimidated by the defendant and does not want to provoke any violence from him. Nothing further, Your Honor.
All right, thank you. Ms. Armstrong?
Judge, Mr. Mclennan has worked for the city of Atlanta since 2015. He's actually currently on medical leave because he got surgery on his knee in January. And this allegedly happened when his knee was still not what it should be. So there is some sincere doubts about his ability to even attempt to inflict violence upon not one, but 2 people, given the fact that he had to go through major surgery on his knee. At the time, this was before the complaining witness and my client broke up, as stated by the state. They're no longer together. They were arguing a lot. He left the house because he didn't want things to escalate. And then a warrant was issued because, quite frankly, the claim that didn't happen. People can get knots on their heads from other things. There's no evidence. There's no direct evidence that whatever the state alleges that my client did caused what allegedly appeared to be on the complaining witness's head. It is clear that the complaining witness is not going to cooperate in the prosecution of this matter, nor has the state indicated that they had any contact with Ms. Huff. So we are asking your honor to consider a signature bond in this case. This is a man who works for our city. He contributes to society. He actually needs to be out in addition because he needs to attend physical therapy. So his knee will heal properly so he can continue working for the city. So we are asking your honor to consider a signature bond.
On the simple assault's 1,000, on the battery is 3,000. Total bond is a $4,000 signature bond through pretrial services. No contact with Destiny Huff, no contact with Contressa Crowder. And that means no contact in person through any kind of electronic device, through social media, as well as through a third party. Mr. Mclennan is not to consume any illegal drugs. He may have prescription drugs if he has the prescription for it. No alcoholic beverages, no weapons, and no firearms. And he is to complete a 1-day anger awareness program through pretrial services. He will report to pretrial once a month. And if he violates any of the conditions of this bond, fails to report or fails to show up in court, then this $4,000 signature bond will convert to a surety bond. Thank you.
So you should go to the breakout session with Mr. Rozier.
All righty.
That is my case, Your Honor.
All right. Deputy, have we addressed everybody else in the courtroom?
Now, Ms. Gann had gonna do Ms. Armstrong cases first. So
Okay, I'll be in a breakout room for Mr. Rozier. Mr. Rozier's case is 22 CR 001175C. This is Travis Rozier, is that correct?
Rozier. Yes.
Okay, Rozier. And he is accused of simple battery domestic violence from March 2nd, 2022. Mr. Rozier, you've been advised of your right to remain silent, and your attorney is Ms. Sarah Armstrong. Mr. Rozier, we will be with you shortly. Ms. Lewis, or the host, if you could place me, Ms. Armstrong, and Ms. Webb in a breakout room, please. Mr. Tucson, and Ms. Falk as well. Any priors on Mr. Rozier?
This is third. He don't have any violence. 2011 driving without a valid license. 2015 misdemeanor possession of marijuana.
Thank you. All right, we are addressing the case of State versus Travis Darnell Rozier, and we've had a sidebar with both the state and the defense. Both parties have had an opportunity to present their arguments. Based on the arguments presented by both sides, the court has reached this conclusion. Based on Mr. Rozier's criminal history record, based on the allegations set forth in the warrant and the arguments presented by counsel, bond is set at $2,000. It's going to be a surety bond. He's to have no contact with Ethel Lee Rozier Turner. He's to stay away from the family home. His next court date is going to be March 17th. And the defense is going to ask for the proper evaluation with regard to this case. Mr. Rozier, you may return to, if you make bond, you may return to your family home one time only to retrieve your personal belongings. And this visit must be in the company of a police officer. No drugs, no illegal drugs, no alcoholic beverages, no weapons, and no firearms. Thank you.
Yes, we have number 1, Mr. Brownton.
And Judge, that concludes my business. May I be excused?
Yes, Ms. Armstrong, you have a good day. Thank you.
Thank you.
I'm so sorry. Could you repeat the name again? I didn't
Number
catch
1, Mr. Brownton.
Mr. Brownton. Jonathan Brownton, Sr. is accused of simple battery domestic violence on December 27, 2021, in case 22 CR 001172D. Mr. Brownton, you have been advised of your right to remain silent, and your attorney is going to be Ms. Wanda Gant. And any priors, Mr. Toussaint?
5th arrest. Last was 2019 probation violation. Criminal attempt to commit a felony. 2018 giving false name, obstruction, conviction out of DeKalb County. He's on probation for the criminal attempt to commit a felony. Robbery is the underlying charge.
All right.
2013.
I'm sorry. That's good. Yeah, thank you. Ms. Arnold?
Yes, Your Honor, the state is requesting a $5,000 surety for the simple battery family violence. No further contact with Trunetta Hambrick. Trunetta spelled Trunetta, Hambrick spelled Hambrick. A stay away from 1940 Fisher Road Southeast in Atlanta, a one-day anger awareness course, and no drugs, alcohol, or weapons. Your Honor, we do believe that the defendant will reoffend. One, based on the facts of this case, where the defendant had no problem coming into Ms. Hambrick's home around 3 a.m. and punching her in the back for reasons that we understand, because the defendant asked if she would be involved in a relationship with another woman, to which she replied no, and that she would like to move forward with their divorce. Additionally, when Ms. Hambrick spoke with our victim's advocate, she advised that this was not the first time the defendant had been physical with her, but we will give it to the defendant that this is the first time he attempted to choke her. We know the defense will say that the defendant's record does not indicate there's been any abuse, but this is not a true indicator. As we know, with the cycle of violence, sometimes victims are ashamed or afraid. So we would just like to make it known that based on our victims advising to our victim advocate, she said that this was not the first time, Your Honor. So for these reasons, where the victim has stated that it has happened before, and more importantly, for the safety of our victim, we are requesting the bond of the $5,000 surety with the conditions as stated. And one last thing to mention, Your Honor, the victim did say that because of this incident, DFACS was involved, and that they have made it so that the defendant is not able to see his child without a third party. At this point, Ms. Hambrick has been acting as the third party, or as someone, she's acting as the person that's supervising the visitation with their son. So for the sake of her son, she did say that she is not opposed to no further violent contact, but we would again ask that there be no further contact, and that another person be used for visitation. Thank you, Your Honor.
Thank you. And so right now, visitation with the child has been set up by the defects plan. Is that correct?
Yes, Your Honor.
Okay, it's not a plan set up by a superior court, say, for example, in a separation or in a divorce proceeding.
No, Your Honor. It's
Okay.
It's from DFACS.
Okay, thank you. Ms. Gant?
All right, thank you, Your Honor. Mr. Jonathan Brownton is 25 years old. He has been in the Atlanta area all of his life. He has family here, including his wife, from which he is separated and is in the process of divorcing. They share a 2-year-old child together. Your Honor, we are unopposed to the stay away. Mr. Brownton indicates that he no longer resides at 1940 Fisher, and we do not need a law enforcement escort as he has no belongings there. He has completed, he has obtained a GED. He is currently working at Cash America Pawn. He just recently was promoted as an assistant manager, and he's due back at work today. Regarding the allegations, he denies the allegations, Your Honor. He states that he initiated divorce proceedings, and after doing so, his wife, Ms. Trunetta Hambrick, has been basically creating these baseless allegations against him. He, yes, he admits to being at the property on December 27th, but it was to spend time with his son, Your Honor. He denies making any physical contact with her whatsoever, and he states that Ms. Hambrick has in fact been using his child as a pawn to limit or to prolong the divorce proceedings. Your Honor, regarding my client's history, he denies being on probation. He states that he, according to his probation officer, completed 2 years, and a condition of his probation was to obtain his GED and to find a job. He believes at this time that he is not currently on probation. I am requesting a signature bond on Mr. Brownton's behalf. The last thing that we heard about Mr. Brownton's contact with law enforcement was back in 2019. We have not heard of any allegations whatsoever or any court cases involving Ms. Hambrick. So the state's and the complaining witnesses' allegations, unless they're before this court, Your Honor, should not rely upon them. Furthermore, we do not have any indications or any evidence whatsoever that DFACS is involved in arranging visitation for this child. My client did not indicate that to me, and furthermore, there is nothing in the warrant about that. We are requesting a third-party transfer, and again, my client wants no contact. And again, lastly, we are unopposed to the stay away. And if Your Honor determines that he is ineligible for a signature bond, then I would ask for a bond of no more than $1,000. Thank you.
Bond is set at $3,000. It is a surety bond. No contact with Trunetta Hambrick to stay away from the Ms. Hambrick's residence. Was that the Fisher Road location?
Yes,
Yes,
ma'am.
ma'am.
Okay. No illegal drugs, no alcoholic beverages, and no weapons and no firearms. Visitation with the minor child shall be set forth by a superior court order, either in a divorce proceeding or in a separation proceeding. So depending on who files the lawsuit, they can go ahead and obtain a court order to establish visitation and custody. As he's no longer allowed to have contact with Ms. Trunetta Hambrick, the current plan, if there one exists in accordance with DFACS, is suspended. Mr. Brownton, you have a right to remain silent. Anything you say about the facts of the case, your statements can and will be used against you. So unless you have a question about your bond.
And I do advise you to remain silent, Mr. Brownton. The judge has ruled.
Yes, ma'am.
All right. Next court date is going to be March 17th.
Next, we got number 5, Mr. Dismukes.
Hey, how you doing, Ron?
Fine, thank you. Did you say this was position 5?
Yes, ma'am.
Okay. All right, just one second. Thank you. Mr. DeMarlo Dismukes is accused of false report of a crime in 22 CR 001167Y from March 2nd, 2022. Mr. Dismukes, you've been advised of your right to remain silent, and your attorney is going to be Ms. Wanda Gant. Mr. Tucson, any priors, please?
No, I have first arrest.
All right. And Ms. Arnold?
Yes, Your Honor. So the state is requesting a $2,500 surety bond for a false report of a crime, and that there be no drugs, alcohol, or weapons. Your Honor, we do believe that the defendant is a flight risk. From what we can tell, his residence is in Alabama, and he has no community ties to the state. Additionally, based on the facts of this case, where the defendant told officers that he had been robbed at gunpoint by 3 Black men that took his vehicle and his wallet and his cell phone, but was actually in Alabama at the time that he said this incident happened. And then officers were able to see that when he did arrive in Atlanta, he willingly gave his vehicle to a man inside the city limits. We are requesting the bond as stated for the $2,500 surety with no drugs, alcohol, or weapons.
Ms. Gant? I'm sorry, Ms. Gant, you unmute, please.
Yes, thank you, Your Honor. Mr. DeMarlo Dismukes is 29 years old. He is from Atlanta, but Your Honor, he has informed me that he has relocated to this area. He has been in Atlanta for the past 2 weeks. He is employed here as a barber. He obtained employment 2 weeks ago. He relocated here to work. He completed high school and he also completed 1 semester in college. Your Honor, my client does not have any prior criminal history. This is a nonviolent offense. He is recommended through pretrial, and furthermore, he disputes the allegations. Therefore, I am requesting a signature bond, Your Honor. And he's 29 years, no prior history. Obviously, he understands the importance of keeping his record clean. So therefore, we do not believe that he's a flight risk. He's anxious to defend against these allegations. Thank you.
It's been in Atlanta for 2 weeks.
For 2 weeks, relocated here to work as a barber.
Not off to a great start. Is the escort court his current address in Riverdale?
Yes, ma'am.
Bond is set at $5,000. It's going to be a signature bond through pretrial services. You will report to pretrial once a month. No illegal drugs and no alcoholic beverages and no weapons and no firearms. You'll be subject to random screens. And if you get arrested again for anything else, I don't care where, Alabama, Georgia, pick a state, anywhere you get arrested, this $5,000 signature bond will be converted to either a surety bond or a cash bond. Thank you. Next court date will be sent to you at your Riverdale address. If you change your address, make sure that we get first dibs of being informed of your new address. Thank you.
Number 6, Mr. Duncan.
James Duncan is accused of public drunkenness and possession use of drug-related objects and our favorite, littering. From March 2nd, 2022. Mr. Duncan, you have been advised of your right to remain silent. Your attorney is Ms. Gant. And Mr. Tucson,
59.
Okay. Does he have any open cases right now, probation or active cases?
We got to open public indecency and drinking in prohibited areas. It's in state court.
Okay.
Yes.
Got it. Ms. Arnold?
Yes, Your Honor. The current bond is set at $500 surety for count 1 for public drunk, $1,000 surety for count 2 for possession and use of drug-related objects, and $500 surety for count 3 for littering, for a total of a $2,000 surety. We are asking that the bond will remain, that there be a stay away from 2531 Lenox Road in Atlanta, alcohol, drug evaluation and treatment, and no drugs, alcohol, or weapons. Your Honor, we believe that the defendant is a flight risk based on his FTA from last year, from September of last year. We also believe that the defendant will reoffend as he was in an intoxicated condition on the sidewalk in front of the extra space storage, using profane language, and also had in his possession a glass pipe with a burnt tip. a drug-related object for which he also has had several arrests for. Just to name a few, he does have 58 cycles, Your Honor, but from 2018, 2019, and 2020, he was arrested for possession and use of drug-related objects, as well as in 2017 and 2016. Then in 2011, he was convicted for an attempt or conspiracy to violate a Georgia Controlled Substance Act and possession and use of a drug-related object. And then also in 2011, he was convicted for possession of cocaine. And then, as pretrial has mentioned, he has the open case for drinking in prohibited areas and public indecency. So for these reasons, Your Honor, we do believe that the defendant will reoffend. So we are asking that the bond would remain. Thank you.
Ms. Gant? I'm sorry.
Mr. Duncan is 50 years old. He has been in Atlanta all of his life. He has family here, including 2 children. We are unopposed to the stay away at 2531 Lenox Road. Mr. Duncan completed 9th grade. At this time, he is unemployed. However, whenever he is able to work, he does landscaping. He does not have the means to pay anything toward bond. Therefore, I am requesting a signature bond, Your Honor. He disputes the allegations, and regarding the state's contentions that he is a flight risk, he is, again, realize the importance of returning to defend against these allegations. And I would just bring to the court's attention that that open case is a 20 COV case. That's part of the backlog. So, you know, he enjoys the presumption of innocence in that case, as well as this current case. And again, for these reasons, Your Honor, I'm requesting a signature bond as he has no means to pay. And given the nature of the offenses, these are non-violent offenses. He did not offer any violence whatsoever. Thank you.
All right. And you mentioned that he has family. Do they all live with him at Boulevard?
Do they, I'm sorry, say it again.
Do they all live at the same location at Boulevard?
No, he indicates that his address is 520 Boulevard, Atlanta, Georgia Northeast.
And where does the family live?
I'm sorry, say it again.
Where does his family live?
May you answer that question, Mr. Duncan? He states that they are in Georgia.
Yes.
Mr. Duncan, if you want to be released on a bond, we need to know who your family is.
My family,
Yes, sir. Who can help you out?
they stay on Campbellton Road.
And do you know how to reach them?
Yeah, I can reach them.
Okay.
They're grown. My kids are grown.
Good. On each count, it's going to be $50. It's going to be a cash bond only. It's $150 cash bond. Next court date is March 17.
I don't have the money to pay, ma'am.
That's why family is so important.
And Mr. Duncan, my comment is directed toward Mr. Duncan. Mr. Duncan, remain silent, please.
Okay.
It's a $150 cash bond, no drinking, no alcoholic beverages, no illegal drugs, no weapons, and no firearms. That's why I was asking about the family, sir. Like I said, they're very important, especially during your time of need, like right now.
I can't pay the bond.
Family will help out. Next court date is March 17th.
Howdy.
You got number 8, Mr. Friday.
Mr. Christian Friday, is middle initial J, is accused of simple assault and criminal trespass from November 11, 2021 in 22 CR 001169G. Mr. Friday, you've been advised of your right to remain silent, and your attorney is Ms. Wanda Gant. Mr. Tucson?
We got first arrest, address says homeless.
All right, thank you. Ms. Arnold?
Yes, Your Honor. So the state is requesting a $2,000 surety for count 1 for the simple assault and a $1,500 surety for count 2 for the criminal trespass, for a total of a $3,500 surety. A stay away from the corner grocery located at 1407 Metropolitan Parkway in Atlanta. No further contact And I'm just going to spell the first name, Your Honor, with Nukeshpumart, last name Patel, Patel, and no drugs, alcohol, or weapons. Your Honor, we do believe that the defendant will reoffend based on the facts of this case where Mr. Patel has stated that the defendant has been coming to the store for over a year now after being continuously asked to not come back. And he was issued a criminal trespass warning on May of 2021 last year, but returned yet again on November 11th. And this last time when he returned, attempted to strike Mr. Patel. So for these reasons, we are requesting the bond as stated with the $3,500 surety and the conditions. Thank you.
Thank you. Ms. Gant?
Thank you, Your Honor. Mr. Christian Friday is 25 years old, and Your Honor, he denies being homeless. He gives an address that I will put in the chat. He has been in Atlanta for 7 years. He has family here. We are unopposed to the 1407. We are unopposed to the stay away at 1407 Metropolitan. He has no reason to return there. Your Honor, Mr. Friday completed 12th grade. He works whenever he can as a mechanic. And he also does yard work with his uncle. He does not have the means to pay much of anything toward bond. Your Honor, he is recommended through pretrial services. He denies the allegations. Therefore, I'm requesting a signature bond on Mr. Friday's behalf. And again, we are unopposed to the stay away and the no contact orders. And he doesn't have any, what I heard from pretrial is that he doesn't have any prior history. So the stay away will certainly take care of any concerns about reoffending at this location. Thank you.
All right. And does he have family who can help him out with bond?
He indicated that he has a sister, Savannah Friday.
On the simple assault, bonds can be set at 2,500. The criminal trespass is 2,500. Total bond is 5,000. It's going to be a signature bond through pretrial services. He is to have no further contact with Mr. Nukesh Patel. He's to stay 200 yards away from, I don't know whether Mr. Friday has fallen asleep. Is he awake?
I'm awake.
You awake?
I'm always awake.
Excellent. Then you know you'll have to stay 2 football fields away from Mr. Patel and the corner store at Metropolitan Parkway. That's 200 yards away. If you're seen anywhere near that location, if you're seen within 200 yards of Mr. Patel, or you try to communicate with him through a third party, in person, electronic device, or through social media, all he has to do is call the authorities and you'll be back in jail. You're not to consume any illegal drugs, no drugs. You're not to consume any alcoholic beverages, no weapons and no firearms. You report to pretrial once a month. If you fail to report, you'll be arrested and your signature bond will be revoked. We will need a current address. You have one, Ms. Gant?
Yes, Your Honor, I will place it in the chat.
All right.
Does he have a phone?
He has a phone as well. I will place that number in there as well.
So how you get this stuff and it's not on his booking sheet?
He provided this information to me during our interview.
I don't have a phone number that I own.
Hey, this per judge. It don't matter. Per judge.
Per judge, and we'll need an address, an email. Do you have an email?
Yes, ma'am.
All right. I can't think of anyone born in your era who doesn't have an email.
And
okay.
I do, Your Honor, I do not have an email address for him.
All right. What's your email, Mr. Friday?
CJ Friday 1@gmail.com.
All right. When you report to pretrial, make sure you update your address, your email address, and your phone number if you get one by then. And you must report to pretrial once a month. Failure to report will result in your arrest. Just make sure you stay away from that market location and from Mr. Patel. Otherwise, you know, we are always glad for new business.
Yes, ma'am.
Thank you, sir.
Yes, we got number 7, Mr. Frazier.
Any idea, Ms. Arnold, how to pronounce the first name?
Marsavic.
Thank you. State versus Marsavics, Holly McCoy Frazier. accused of criminal trespass, 22 CR 001170H, from March 1st, 2022. Mr. Frazier, you've been advised of your right to remain silent, and your attorney is Ms. Gant. Mr. Tucson?
His third arrest. Last arrest was 2020, breaking and entering. It appears to be open, so he's not recommended. Breaking and entering, larceny of a motor vehicle, injury to real property, that's out of North Carolina. 2020 arrest, possession of stolen goods, that's a felony arrest. And this is the first Georgia arrest.
What state was the possession of stolen goods?
Everything come out of North Carolina.
North Carolina, okay. Ms. Arnold?
Yes, Your Honor. The current bond is set at a $2,500 surety. We're asking that the surety remain, that there be a stay away from Sonesta Suites located at 5465 Windward Parkway in Alpharetta, and that there be no drugs, alcohol, or weapons. Your Honor, we do believe that the defendant is going to reoffend based on the facts of this case, where the defendant was already given a previous trespass by police in February, and was cited and was aware that he was not supposed to return to that Sonesta Suites, but returned anyway, and this time damaged a screen window in order to enter the vacant room. So for these reasons, Your Honor, we are requesting that the bond would remain.
Ms. Gant?
Thank you, Your Honor. Mr. Marcevic Frazier is 21 years old. He is residentially challenged. However, he has a mailing address, which I will enter in the chat. We are requesting social worker services to assist with his living situation. He has been in the Atlanta area for the past 3 months. We are unopposed to the stay away at 5465 Windward Parkway, Alpharetta, Georgia. However, Your Honor, Mr. Frazier informs me that he still has clothing and blankets at that location. So we are requesting a one-time law enforcement escort to retrieve his belongings. Mr. Frazier completed high school. He has been working at McDonald's for the past 2 months, and he is unsure if he still has a job. Therefore, he is anxious to be released so that he can return to work if he still has a job. Your Honor, I am requesting a signature bond on Mr. Frazier's behalf, and if Your Honor determines that he is ineligible, then the lowest bond possible, he states that he has no more than $100 to pay toward bond.
Bond's going to be set at $500. It's going to be a surety bond. Next court date is March 17. Stay away from 5465 Windward Parkway in Alpharetta, Georgia, the Sonesta Suites. He may visit the lobby, only the lobby of this particular motel, in the company of a police officer. If this particular motel has already retrieved his belongings from his room and boxed it somewhere, he may pick it up if there's such item exists there. Otherwise, he's allowed one-time visit. The visit cannot exceed 30 minutes to retrieve the box with his items in it. Thank you.
And finally, we got number 4, Mr. DeBose. Mr. DeBose.
Okay. And Mr. Bose, who would like to be in the breakout room?
Ms. Arnold and Ms. Falk and Ms. Gant.
Is number 3 reset? Still?
Yes, see that, Grady.
Okay.
All right, we'll be with you all very, very shortly. Mr. Jordan or Ms. Lewis, could you place Ms. Shumaya, Ms. Wanda Gant, Ms. Arnold, Ms. Falk, and myself in a breakout room, please? Mr. Bose, we'll be You'll give me a second, please. All right, we have State versus Ms. Beverly DeBose. Ms. DeBose, you have been accused of battery, domestic violence from an alleged date of March 2nd, 2022. You've been advised of your right to remain silent, and your attorney is going to be Ms. Wanda Gant. We have had a sidebar conference with your attorney, with the prosecutor, as well as the alleged victim. And based on the information presented so far, we are going to set your bond at $2,000. It is going to be a surety bond. No contact with Shumaya Jones. In other words, you cannot reach out to Ms. Jones. You are not to speak to her in any way, form, or manner. You are to stay away from the incident location. No illegal drugs, no alcoholic beverages, and no weapons. And I would need you to be medically compliant with any treatment and any medication that has been prescribed to you. Your next court date is going to be March 17, pending an evaluation to be implemented in accordance with the defendant's wishes. All right, that concludes this case. Courtroom 2, do we have anybody else?
No, ma'am.
All right, we will see you tomorrow. Thank you.
Thank you.
To go over the calendar, position 1, Brownton, was a $3,000 surety bond. Reset date is March 17. Position 2 is a 2,500 signature bond through pretrial, further notice for arraignment. Position 3 is a Grady reset. Oh, I'm sorry, who?
Co-signer on number 2.
On number 2, that's a co-signer. Yes, Mr. Reginald Clay. Position 3 is a Grady reset to tomorrow, March 5th.
March 4th.
March 4th. Oh, that's right. Sorry. Thank you. Mr. Bose is a $2,000 surety bond, reset date March 17th, pending an evaluation. Position 5 is a $5,000 signature bond through pretrial. Per judge, right?
Yeah, that's fine.
Okay.
It is per judge?
It wasn't, but hey, you know.
Yeah, I have it as
Okay.
per judge.
James
Oh.
Duncan, position 6 is a $150 cash bond only. Reset date is March 17th. Position 7, Frazier is a was a 500 surety bond. Reset date is March 17th, and to stay away from that semester. Position 8 is a $5,000 signature bond through pretrial, 2,500 on each count.
And
Per
that's-
judge.
Per judge. That's the one that was put. Thank you. Position 9, Samar Grant is a 2,500 signature bond through pretrial, further notice for arraignment. Position 10 is a 3,500 signature bond through pretrial per judge. Position 11, Ira Johnson, is a 2,500 surety bond, and that is reset to March 17th. Position 12, March 17th on a $1,000 surety bond, $500 on each count. Position 13 is, and that's also reset to March 17th. Position 13 is a $4,000 signature bond through pretrial, further notice for arraignment. Position 14 is a $2,000 surety bond, reset date March 17th, pending evaluation.
What was number 7?
Was a $500 surety bond.
I'm about to
Reset.
bring the waiver in there for you. Sign.
For Clay?
Yes.
Okay, got it. Okay, folks, any questions?
Yes, I do. Position. Which position did Mr. Toussaint ask about?
The waiver was position 2, Brian Clay.
Oh, okay. I thought he
Waiver.
said something about, so position 7, Frazier, it's $5,000 surety, correct?
No, 500.
$500 for position 7.
Yes.
Okay, thank you, Your Honor.
All right, folks, we good? Okay, I'll see y'all tomorrow. Take
Okay.
care.
Thank you.
Enjoy
Bye,
your
thank
Thursday.
you.
Bye-bye.
Thank you, Your Honor.